You're talking about all this other stuff that's irrelevant. Nice you put it in there, but it doesn't matter. The case in Wong Kim Ark was to people in the country legally, whereby his own act, he had made himself the subject of a foreign power, had taken him out under the act of Congress. Okay, I was gonna say, like, what are we even reading this for? This case had nothing to do with birthright citizenship. Like, what? What is this case? These united colonies are, and of right ought to be, free and independent states, and that they are absolved from all allegiance to the British Crown. Afuera! A brilliant brief in the United States Supreme Court. This one coming from a very familiar face. You may recognize his name, John Eastman, a man who was put through the ringer by the Democrats and the lawfare state back when he was helping President Trump regain the White House. And what has happened here is his organization, called the Constitutional Counsel Group, is submitting this brief as a friend of the court in a battle about birthright citizenship. And you know that this is a consolidation of 3 cases currently in the Supreme Court of the United States, waiting for them to come down and answer the question, can an illegal alien who is in our country illegally without any lawful status, if they pop out a kid, does that kid automatically have citizenship? The default status quo has been to grant that kid citizenship, but that's not what the law says. It's not what the law has ever said. And John Eastman, who you can follow over here, he is a constitutional law professor and dean, Chapman University, Fowler School of Law, senior fellow, the Claremont Institute, all the things. Awesome dude. Make sure you give him a follow on X. But here's what has been submitted. Of course, birthright citizenship is going to be a major issue, and the Supreme Court is ripe to come down and clarify this. But here is what this says. Now, we're here on behalf of the principles of the American founding and the importance of extending citizenship here only to those who do not owe allegiance to foreign powers other than America. Now, the center has previously appeared before. We've also worked with Ed Meese. Ed Meese was huge in the Jack Smith cases, when you remember. And we've been here before, so you know who we are. But here's where we're starting. They say, all right, Supreme Court, listen. The United States has, at this point, only made a modest request to restrict the scope of multiple universal preliminary injunctions. That's it. We want to just make some minor changes. Nothing big. Now, amicus agrees that the propriety and the constitutionality of these universal injunctions is an issue that desperately needs to be addressed and resolved by the court, and that these cases present a good vehicle for doing so. So you can solve this now, but we also believe that the merits of the underlying issue are ripe for consideration by this court as well, however. So in other words, Supreme Court, 2 issues here. 1, you could stop this injunction stuff now and deal with it this way, or you can just deal with the 14th Amendment issue and just say, actually, we'll just hear it on the merits and say 14th Amendment doesn't cover illegals. The lower courts have all treated the issue in their rulings below as one of pure law. They say it's clear. They say in extensive opinions that the president's executive order was facially unconstitutional. Now, they were right in one respect. The question about whether the citizenship clause of the 14th Amendment mandates the grant of citizenship to all but a few persons, like children of diplomats or soldiers of invading armies, is purely a legal issue. And further percolation on this matter is really not necessary. So we don't need any more fact-finding at all. We don't need to determine, is birthright citizenship like impacting this, or how much is it happening? We don't need fact-finding on it. It's just a question of law. What does the Constitution say? What does the amendment say about birthright citizenship? They say, particularly, given the fact that the scope of the citizenship clause has previously been addressed by the Supreme Court in prior cases. So you've already talked about it. So just, clarify. So this briefing, therefore, focuses on the substance of the matter. So does the 14th Amendment apply or not? Here's what John Eastman says. All right, contrary to the assertions of the lower courts and others, the respondents, this court, the Supreme Court, has never held that the 14th Amendment compels the grant of automatic citizenship to children born in the United States to parents who are merely temporarily visitors or unlawfully present. Okay, so if you're here on a visa temporarily, or if you're here illegally, you have never, not one time, and I agree with this, we read through Wong Kim Ark here, saying there is precedent for it is a misread of that case. Those people in Wong Kim Ark, he's going to explain it, I'm sure, were lawfully here in the country. Both the district court and for Maryland and Washington and others, they say that this is definitively settled. They rely on an expansive reading, which means a broad reading, like they're just reading a bunch of garbage into it that doesn't exist into it. Wong Kim Ark and the other cases, which we've covered here. But this reliance is flawed. Now here's why. As described more fully below, the actual holding in Wong Kim Ark was much narrower. It was resolving only the specific question that was presented. This question: does the citizenship of a child born in the United States to parents who were subject of a foreign sovereign, they were Chinese, but who had established permanent domicile and residence in the United States, okay? Foreigners, but lawfully domiciled and residents. Any language in the opinion saying it applies to illegal, like the parents were in here illegally, any language that suggests a broader rule that it should also apply to non-domiciled, non-legal people is non-binding dicta, which means it's not relevant to the holding. It's just like, oh, it's nice they put it in there, but the question before the court is about this. The holding was about that, about this. You're talking about all this other stuff that's irrelevant. Nice you put it in there, but it doesn't matter. The case in Wong Kim Ark was to people in the country legally. Now, furthermore, the subsequent cases cited by the respondents in the lower courts don't contain any holdings on this question. So why are they citing them? John Eastman writes, as demonstrated below, the statements about citizenship in those cases were either dicta, unnecessary to the decisions, or just background assumptions that were made without any actual analysis. And we're going to go through it. He says, because the Supreme Court has never squarely addressed this, whether illegals can have babies who are citizens, and has never held that temporary visitors or illegal aliens are citizens, the question is open. It has not been settled at all. He writes, both the lower courts and the respondents here, they misconstrue the scope of Wong Kim Ark. They treat the case as conclusively establishing that virtually all people born here on the geographic soil are automatic citizens. They say there's only a few exceptions like diplomats or soldiers, but they don't read the case right. They dismiss the critical fact, that the parents in Wong Kim Ark were lawful, permanent domiciled people. They just say it's incidental. It doesn't matter. Oh, it's not vital to the court's reasoning. It doesn't matter because Wong Kim was born in California, so that's all that mattered. But this is totally untenable. It ignores both the court's framing of the issue and all of the other things are just dicta. The Wong Kim Ark court explicitly described the question presented. Okay, they quoted it. They said, this is what we're here to answer today. It's about a child in the United States whose parents have permanent domicile and residence and are there carrying on business. Is that kid a citizen? Now, this fact is not incidental. It's foundational to the entire certified question, the stipulated record, and the entire analysis. The terms domicile, domiciled, permanent domicile, domiciled residence appear 30 times throughout the majority and the dissent, underscoring the centrality of lawful permanent residence in the reasoning. The legal significance of domicile cannot be overstated here. It's not merely physical presence, okay? It's lawful establishment of a permanent home with an intent to remain indefinitely. Those are factors like checkboxes that show what it is. Something fundamentally distinct from the transient presence, right? If we're having a legal test, if you check these boxes, oh, it's domiciled. If you're over here, you're a resident, you're temporary, right? Accordingly, the actual holding of Wong Kim Ark, the binding legal determination is based on the specific question presented, is literally limited to citizenship of children born in the United States, the parents who are lawfully in the country. Statements in the opinion that suggest broader application based solely on birth without regard to the parental allegiance exceed the factual predicate and are non-binding dicta. Even Chief Justice Marshall explained, saying general expressions taken in connection with the case but extending beyond the case may be respected, but they should not control the judgment, okay? You don't want a question coming to the court and then the judges are just like, well, since we're talking about this, I think we should also change this and change that. And this also applies over here. It's like, no, it's narrowly limited to what is before it. This was lawful residence. So they don't get to then include all the unlawful residents as well. Saying the lower courts and the illegal lawyers rely on dicta. They say, well, citizenship of children born to temporary visitors is well settled, but that's profoundly mistaken. This court has never held that. The specific holding in Wong Kim Ark doesn't compel that. Now, they also err in dismissing the importance of parental domicile. It's true the word domicile doesn't appear in the 14th Amendment, but the constitutional text does require subject to the jurisdiction thereof, and domicile is critical to understanding that phrase. Domicile reflects a voluntary and permanent submission to a sovereign's authority, different from just passing through. It's rooted in the foundation of the 14th Amendment. In fact, its drafters made very clear that being subject to the jurisdiction meant owing complete, undivided allegiance, not just merely being physically there. It's more than just dropping a baby on the ground. You got to be subject to the jurisdiction thereof. You can't violate the law and then claim a benefit of your violation of the law. If you subject yourself to the jurisdiction, that means you're here lawfully. Have a baby. Indeed, the debates explicitly contrasted permanent settlers, like Chinese migrants with lawful domicile, with temporary sojourners, and explained one gets citizenship, the other does not. Thus, it's not incidental, okay? It's the key holding. It's central to the court's reasoning. The court's holding rests on the narrow ground of children born to lawfully domiciled parents, not on broad endorsement of unrestricted jus soli. And history supports our claims as well. The illegal lawyers who want citizenship for their illegalities, they attempt to bolster their argument with a patchwork of his sources. And they say, oh, it's all well settled. Look, it's well settled. They say Casa says, well, this case said the Supreme Court assumed that all persons born here geographically were citizens. That's not even true. We read the case. Here's what the case actually says. As the case notes, the individual whose citizenship was at issue is this guy called Jared Shattuck. He was born in Connecticut before the American Revolution. Wow. Saw some stuff, man. So he was therefore a British subject at birth who was clearly subject to English rule of jus soli. He became an American citizen through his parents as a result of the success in the Revolutionary War, not because of some American rule of birthright citizenship. Okay. Like, well, that case, he kind of got birthright. It's like, what? The Revolutionary War, dude? The issue in the case was whether his subsequent removal to the island of St. Thomas, where by his own act he had made himself the subject of a foreign power, had taken him out under the act of Congress. Okay, I was going to say, I'm like, what are we even reading this for? This case had nothing to do with birthright citizenship. I'm like, what? What is this case? Okay, thank you. Now, they also misunderstand another case. John Eastman tells us that they also rely on this other case, Lynch versus Clark, but it's not any better. The Casa brief, the same people who were representing Kilmar, they assert that Lynch conclusively showed that all children born here are citizens without regard to any allegiance of their parents. But they say that's ridiculous. That case was merely a state court decision. It was issued pursuant to an express provision of the New York State Constitution that specifically adopted English common law. So it's not really applicable to this. The citation of Lynch that they attribute generally to the Congressional Globe appears to originate, man, John Eastman has gone down the rabbit hole, baby, says it appears to come from a single reference by Representative William Lawrence during the 1866 Civil Rights Act debate, where Lawrence cited in a supposed note that doesn't even mention the case. So the commentaries stand for the opposite proposition, actually, saying that not just birth, but allegiance as well was necessary for automatic citizens. So actually what you cited supports me, if you look into it. He actually cites it. Natives are all persons born within the jurisdiction and allegiance. See that? So, all right. Well, they also cite this isolated reference. It's also in stark contrast to the Civil Rights Act, 1866 Civil Rights Act, said all persons born in the United States and not subject to any foreign power. There are other explicit statements in the bill. All the stuff preempted the 14th. Representative John Bingham explained in 1866, clarified that it applied to those born with the jurisdiction thereof and parents not owing any allegiance. Then we got the Act's sponsor and others. If you owe allegiance, they talked about it a lot. The same is true during the follow-on debate over the 14th Amendment and their primary sponsors too. There was subject to the jurisdiction included, full and complete jurisdiction included, the same jurisdiction that applies to everybody. He explicitly noted this would exclude children to foreigners and aliens. Why? They don't fall under complete jurisdiction. Other senators at the time strongly concurred. Oh, yes, here. This requirement rooted in consent and political allegiance is better than just the concept of jus soli, which is citizenship by blood, citizenship by land. And allegiance is introducing, right? In other words, like if your parents French and you're born to your parents by blood, you're also French, no matter where you're born, kind of a thing. Also, if you're just dropped there, that confers citizenship. So it's like an enmeshment of the two. If you're born here and you have allegiance, then you count. So they also misread these other commentaries from Justice Story. They say, while acknowledging that his view is a reasonable qualification of this, but it should not apply to children of parents in certain situations. His broader jurisprudence confirms this understanding. The judge, Justice Story, who's a very highly cited judge, recognized significant limitations on the application of common law in America. There is hardly any greater conflict between the common law and the principles of the American founding than the repudiation of the perpetual and non-renounceable allegiance to the king, right? The respondent's reliance on Story's remark concerning the state of public law and the near automatic jus soli ignores the fundamental direction and the principles of his analysis. So if it's just citizenship by land and not by blood or allegiance, that's an overread. Then they go through some other comments from some other senators, and John Eastman continues. He brings us back to Wong Kim Ark. He says, first of all, they're relying on a bunch of dicta. The court in Hirabayashi, for example, stated that 2/3 of the persons of Japanese descent subject to the challenge curfew were citizens because they were born in the United States. But you got to view that in context. Like, that was not about that per se. Both parents were domiciled in the United States. The decision itself acknowledges that this person was born in Seattle in 1918, parents who would come from Japan to the United States and never return back to Japan. Other sources say that they were permanently here, permanently domiciled in the United States. So you can't rely on that to automatically extend that principle to illegals. Same thing with another case, and so too with this case. Now, this case is a little bit different. The court statements in the consolidated cases that the children were citizens were necessary in light of the ultimate holding that the parents could not be deported, so it's another deportation interpretation case. But what these cases show is that the more expansive readings of Wong Kim Ark that are advanced by them, more than a half century, tell us little about the original meaning, and they are dicta. And so the contrary evidence is compelling. So he just destroyed their case, and now he's going to explain why the correct interpretation is that birthright citizenship is not automatic for illegals. He says the American Revolution rejected the feudal doctrine of birthright citizen subjectship in favor of citizenship based on consent and allegiance. Okay, we are not subjects here. You got to have some allegiance. Understanding the citizenship clause of the 14th Amendment requires appreciating the revolutionary break from the English feudal concepts of subjectship. The modern notion of birthright citizenship, an automatic birthright citizenship based solely on the accident of location of birth, is an inheritance from English common law of natural born subjectship. You're just born, you're a subject of the king. That's not how we do things here. Under English common law, birth within the king's dominions automatically said you're a natural born subject, you're mine. Blackstone described this natural allegiance as a debt of gratitude. You cannot forfeit, you cannot cancel, you cannot alter it. This bond of allegiance was perpetual, indissoluble, a feudal tie grounded in the subject and the sovereign. There's no act of consent at all, like little slaves and subjects, which is why I've never really understood that over there with the king and the queen and all that garbage. This conception explicitly denied the right of expatriation. Once born a subject, the person remained a subject for life, whether you like it or not. But then America came around. The American Revolution constituted a fundamental repudiation of this feudal model. The Declaration of Independence proclaimed that governments derive their just powers from the consent of the governed, and that the people possess an inherent right to alter or abolish any government destructive of their rights. And if that were not a clear enough repudiation of the English rule of perpetual allegiance, the Declaration's closing paragraph is unmistakable. It declared that these united colonies are, and of right ought to be, free and independent states, and that they are absolved from all allegiance to the British crown. Afuera! Now, as Jefferson wrote even before 1776, the right of expatriation, the right of departing from the country in which chance, not choice, has placed them, is a natural right inherent in all men. The very act of declaring independence, absolving the colonies from all loyalties and allegiance to the British crown, was an exercise of this natural right, a rejection of perpetual allegiance imposed by mere accident of birth and the English doctrine of jus soli, citizenship by geography. Thus, the court transformed the legal conception of political membership from one based on birthright subjectship to one based on mutual consent. Citizenship in the American Republic became predicated not on geographical happenstance, but on voluntary allegiance to a political community that itself consents to the individual's membership. The Expatriation Act of 1868, enacted contemporaneously with the 14th Amendment, confirmed that. It declared that the right of expatriation is a natural right and an inherent right of all people. You're allowed to leave. Any declaration, instruction, opinion, order, unless you're, wanted to leave the taxes, you got to really work hard to do that. Any officer of the United States which denies, restricts, impairs, or questions the rights of expatriation is inconsistent with the fundamental principles of the Republic. Congress repudiated the feudal doctrine of perpetual allegiance upon which the English rule of jus soli had rested. And so accordingly, the interpretation of the 14th Amendment and the Citizenship Clause must proceed from this foundational principle of mutual consent and allegiance, not from the feudal doctrine of location of birth. So then we talk about antebellum law and Civil War stuff. Says the revolutionary shift from the perpetual subjectship to citizenship was not just rhetorical. It shaped the American law throughout the antebellum period. Courts, lawmakers, legal commentators all recognized that allegiance, often determined by parental status and voluntary assumption, was critical to citizenship. Like, you got to want it. You have to be subject to the jurisdiction thereof. If you violate the law, specifically repudiating the law because you broke in illegally. Early decisions illustrate that the place of birth was not always dispositive for determining citizenship. The court considered the citizenship of a person born in New York near the time of the Declaration of Independence and held that the son's election and character followed that of his father, who was loyal to Britain. Because the father maintained allegiance to Britain, the son was British, despite being born in the United States, unless he affirmatively disavowed that allegiance when he reached the majority, and he didn't do it. This approach, focusing on parental allegiance overriding birthplace, sharply departed from the English rule where you're born and you're a subject. Similarly, in 1875, several years after the 14th Amendment and its ratification, the court reviewed the understanding of citizenship as it existed prior to the 14th Amendment. Chief Justice Waite wrote, writing for the court, observed that while it was never doubted that all children born in a country of parents who were its citizens that became themselves citizens. As for the distinct group of those born within the jurisdiction without reference to the citizenship of their parents, there have been doubts. If their parents are not citizens, there have been doubts. So then we get to 1866 and the Civil Rights Act, which is what turned into the 14th Amendment. And here's what happened. Further compelling evidence that the 14th Amendment was not intended to get automatic citizenship based on birth location. We can look at the Civil Rights Act of 1866. It was the same Congress that passed the 14th. The act sought to secure citizenship for the freedmen following the abolition of slavery. Its opening sentence defined the prerequisites for citizenship: that all persons born in the U.S. and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the U.S. The language explicitly links birthright citizenship to allegiance. Now, by conditioning citizenship on not being subject to any foreign power, the act plainly excluded children born on U.S. soil to parents who were citizens of foreign nations. During the debates, they talked about this too. Lyman Trumbull confirmed this understanding, explained that the clause referred to those whose allegiance solely to the United States was on record. Representative John Bingham, another key figure in the 14th Amendment, was even more direct. He stated the understanding derived from the Constitution itself was that every human being born within the jurisdiction of the United States, of the parents not owing allegiance to any foreign sovereignty, is a natural born citizen. Otherwise, you belong to them. Recognizing that a statute might be repealed or declared unconstitutional, the framers sought to embed these principles and the allegiance requirement in the 14th Amendment. Okay, hard code that puppy into the Constitution. Now, the shift in phrasing from the acts not subject to any foreign power to subject to the jurisdiction thereof was considered a better formulation. It was the same thing, ensuring citizenship was conferred upon those who had allegiance. They were basically the same thing. They just changed it to be a little bit more clear. Now, any ambiguity surrounding the phrase was definitively resolved during the Senate debates. They made their intended meaning abundantly clear. The phrase required full political allegiance associated with citizenship, not merely partial, territorial, or jurisdictional at all. Senator Lyman, chairman of the Senate Judiciary Committee at the time, basically the same guy as Chuck Grassley right now, when pressed on the phrase about Indians, he said, "What do we mean by subject to the jurisdiction thereof?" He says, "Not owing allegiance to anybody else." That's what it means. And if you're a citizen of another country, then you belong to them. He reinforced this by stating it excluded those even owing partial allegiance. Nope, even if it's partial allegiance, nope, it's got to be complete allegiance, complete jurisdiction of the United States. Otherwise, no go. This guy, Senator Jacob Howard, introduced it too. He said the same thing, full, complete jurisdiction. If you're not subject to some foreign power and you're born here, you're ours. Otherwise, you're theirs. These explicit explanations leave no room for doubt, and you should hear this case accordingly. Now, the court's earliest interpretation came out in some of the slaughterhouse cases, decided just 4 years after the amendment was ratified. Now, there was some dicta that the phrase subject to its jurisdiction was intended to exclude from its operation the children of ministers, consuls, citizens of foreign states, and more. Now, this understanding, requiring more than mere birth, became the holding in Elk versus Wilkins. There, the court held John Elk, an American Indian born within the territorial U.S., but who owed allegiance to his tribe, was not a citizen. They said he's subject to their jurisdiction. Because Elk owed allegiance to his tribe at birth, he was not subject to the complete jurisdiction of the United States and therefore belonged to them. So same thing, saying this interpretation after the 14th, requiring complete allegiance for birthright citizenship, was shared by the leading commenters at the time, probably hosting their own little podcast. Thomas Cooley, the most prominent constitutional treatise writer, that was their podcast version back in the day, explicitly adopted the view articulated by Senators Trumbull and Howard. Yeah, he published a lot of it. The executive branch responsible for implementing the law initially concurred. In fact, decisions by secretaries of states in the 1880s said that children born to parents only temporarily here were not citizens. Sorry. And they cited Wong Kim Ark. These early interpretations by leading jurists say that's what the law is. Now, you can't change that now. In fact, we also have the Indian Citizenship Act of 1924, which also came out. This is the clearest example that the political branches of government did not read the Wong Kim Ark case or the 14th Amendment itself as conferring citizenship automatically. Why? They had to pass the Indian Citizenship Act. This act declared that all non-citizen Indians born within the U.S. be declared citizens. The 14th Amendment didn't do it. The act had to do it. The very necessity of this act shows, yeah, Congress doesn't think that if you're just born here, you're good. Got to have allegiance. That's why you had to pass the Indian Act. If the broad interpretation of the Citizenship Clause advanced, saying it's just geography, if that were correct, then the entire Indian Act would have been entirely superfluous. We wouldn't have needed it because they would have been citizens automatically, but they weren't. Those individuals who were made citizens would have already been citizens, but Congress knew that they weren't. They were in allegiance to their their tribes and we corrected or made them citizens after the fact. It was 60 years that they were not citizens until we did that. So if they're illegal in our country and they continue to owe allegiance to home countries, their parents, if they're not subject to our jurisdiction, then they are not citizens. And Eastman wraps it up. He says another indication that birth on soil is not understood to confer automatic citizenship also appears in a pre-1966 passport application. At the time, regulations required applicants to disclose not only their own birth details, but also their father's name, date, and place of birth and residence. If the father was foreign born, the application required information on his immigration and status forms. If the place of birth alone sufficed under a well-settled interpretation of the citizenship clause, he wouldn't have needed to disclose that. So we do think about parental status as it being important, and that's because of the Constitution. So in sum, John Eastman wraps it up. He says, this court should not only stay the universal injunctions issued in the birthright citizenship cases, but it should also resolve the merits question and say, subject to the jurisdiction thereof means a complete jurisdiction, not merely a territorial jurisdiction, and therefore does not confer automatic citizenship to children of temporary sojourners or those present in the United States here illegally.